5 seconds to go. Start. However, via amendment in 2013, the words trial for any scheduled offence were replaced with the words trial of an offence under this Act. It is urged that for the property to qualify as proceeds of crime, it must be connected in some way with the activity related to the scheduled offence, meaning thereby that if there is no scheduled offence, there can be no property derived directly or indirectly, thus, an irrefutable conclusion that a scheduled offence is a prerequisite for generation of proceeds of crime. It is further argued that an explanation has been added to section 44(1)(d) of the PMLA by way of Finance number 2 Act 2019, which posits that a trial under the PMLA can proceed independent of the trial of scheduled offence. It is submitted that the explanation is being given a mischievous interpretation when it ought to be read plainly and simply. It is stated that the explanation relates only to the special court and not the trial of the scheduled offence. It is submitted that a special court can never convict a person under the PMLA without returning a finding that a scheduled offence has been committed. It is submitted that the application of CRPC is necessary since it is a procedure established by law and there cannot be any investigation outside the purview of section 154 or 155 of the CRPC. Reference is made to the constitutional safeguards of responsibility and fairness. It is submitted that the Act itself under section 65 provides for the applicability of the CRPC. It is pointed out that several safeguards, procedural in nature, are being violated. To illustrate a few, non-registration of FIR, lack of a case diary, restricted access to the ECIR, violation of section 161 of the CRPC, section 41A of the CRPC, lack of magisterial permission under section 155 of the CRPC. Such unguided use of power to investigate and prosecute any person violates Articles 14 and 21 of the Constitution. Another argument raised by the Learned Counsel is that the ED officers are police officers. It is submitted that the determination of the same depends on what is the object and purpose of the special statute and the nature of power exercised by such officers. The first argument in this regard is that if it can be shown that in order to achieve the objectives of the special statute, preventive and detection steps to curb crime are permitted and coercive powers are vested, then such an officer is a police officer. Further, such an officer is covered within the ambit of sections 25 and 26 of the Indian Evidence Act 1872. In support of the test to gauge the objective of the statute, reference has been made to State of Punjab versus Barkat Ram, wherein it was held a customs officer is not a police officer within the meaning of section 25 of the 1872 Act. It is also stated that police officers had to be construed not in a narrow way but in a wide and popular sense. Reference is made to sections 17 and 18 of the Police Act 1861, whereunder an appointment of special police officers can be made. Stop.